2025 Mid-Year Labor Law Update. Today is sponsored by our partners over at the Workforce Development Board of San Bernardino County, who you'll hear from in just a moment. My name is Anna. I'm the digital media and event strategist here at the California Employers Association. And again, we just want to thank you for taking time out of your morning to train with us today. Before we get into the content, just a couple details to go over with you. So as you see, your audio is muted for today's presentation, but as you're already doing so in the chat, there are going to be lots of opportunities to engage during today's training. If one of the ways you want to engage is by asking some questions about today's content, you can put those into the Q&A box at any time, and we will address those as we go. So as Juliana will be delivering the content, we'll have Mary in the Q&A box helping with your questions. I'll be watching that chat box in case of any technical difficulties. I'll also be dropping some additional resources and hyperlinks for you there. So all in all, you're going to be covered. Handouts will be dropped into the chat box shortly. So once you see the little PDF icon and file name pop up, you can click that and it'll download locally to your drive. If you are joining from a mobile device, I know sometimes that's where we have a little problem with downloading that PDF. So if you do have any problems, again, I'll be in the chat box. I'm more than happy to help troubleshoot that with you. As you saw when you logged on, the webinar is being recorded and the team over at San Bernardino will be reaching out when that is available for review. And I will also be dropping their YouTube channel in the chat box shortly for you to open up that tab and have that resource. And then last but not least, we'll be inviting you to share your feedback at the end of today's training by participating in a very brief survey. It's only 5 questions, generally takes about a minute to complete, but the feedback that you share with us in that minute, we share with our partners over at San Bernardino, and we just collectively make sure that we are meeting and hopefully exceeding your expectations with trainings like these. So if you can take a moment, the QR code will be on a slide at the very end, and I'll also drop a link, into the chat for your convenience. And this is also how you suggest some topics that you'd like to hear about and learn from in the future. So we really encourage you to take advantage of that. And again, our training today is brought to you by our partners over at San Bernardino County. Today, we are so privileged to be joined by Angelica Villaseñor, Business Services Technician, who is here to share more about those resources available to employers like yourself. Good morning.
Good morning, and good morning to everyone. Thank you, Anna, and thank you everyone for joining us today for our monthly workshop, proudly hosted by the speakers of CEA. As mentioned in the flyer, Workforce Development offers a variety of services to support small businesses throughout San Bernardino County. We operate 3 America's Job Centers located in San Bernardino, Rancho Cucamonga, and Victorville. If you're hiring, we host multiple job fairs across the county and would be happy to assist you with your recruitment needs. One of our most popular services is on-the-job training program. Through WIOA funding, we can reimburse 50% of an employee's wages for up to 3 months while they are being trained on the job. We also have the incumbent worker training, rapid response orientations, and our HR hotline, 1-877-282-3763. We also have an employer toolkit where you can access to various resources as well as links to our partners in San Bernardino County. If this is something you're interested in, please feel free to contact us after the session. Thank you again for being here today, for helping spread the word about our ongoing business and HR workshops. Thank you. Back to you, Anna.
All right. Thank you again, Angelica and Carmela and your entire team behind the scenes for everything that you do for employers and HR professionals in your district. Now I'd love to introduce our trainers today. We have Juliana Gabriel, our Senior HR Compliance Director. She'll be presenting as Mary Bradford, Senior HR Director, will be managing that Q&A. So you are going to be in great hands, and I'm going to hand it over to Juliana.
Thank you, Anna. Thank you, Angelica. We really appreciate your partnership. Now I'd like to introduce California Employers Association, or CEA. We are an HR consulting company. We have members located throughout the state of California and beyond, and our focus is on providing you exceptional HR compliance solutions. If you find that you do need some additional HR support beyond the hotline provided by San Bernardino, you can join us as a CEA member, and that would give you access to our hundreds of sample forms, policies, and toolkits that we're keeping up to date with California's changing requirements. And we can also help you out with projects. So if you need a customized employee handbook, maybe some training for your staff, an HR audit, we can help you out with all of those type of services. We have our website listed here, employers.org, and you are also welcome to call into us directly with any questions. Now, I do want to note that this presentation today is for educational purposes only and should not be relied upon as legal advice. So just a reminder, when you're calling in on the hotline, CEA is not a law firm and we cannot give you legal advice. We also cannot give you legal advice on these trainings. We are always just providing general guidance and best practices. But that said, as Anna mentioned, you're more than welcome to ask us questions about the content today. So Mary is in that Q&A box right now waiting for you. We want to make it as practical as possible. All right, so what is on our agenda today? We have had a pretty jam-packed mid-year season, and in large part that is due to everything that is happening at the federal level with the new presidential administration. So we've had executive orders, increased immigration enforcement. And so you might be wondering, well, how does this impact me as an employer or as a California employer? So we're going to go over some of those key highlights. We're also going to focus on those updates at a state level. So we've had some increasing minimum wages on a local level that happened on July 1st. We also have some new regulations. So we have one on artificial intelligence that's going into effect in October. And we have some new case law, including on meal break rules. So that's always helpful. And then we're going to close out with just some summer reminders and upcoming deadlines for California employers. So go ahead and jumping right in and getting started. We have this theme this year of navigating a new administration. And that is, again, just because there's been so much that's been happening at the federal level. And we understand that there can be a wide range of perspectives on that, but we are really just focusing on compliance. So again, what you need to know as an employer. So one area that we are going to focus on with the increased immigration enforcement is the Form I-9. So we're going to go over some reminders, what you should be doing in terms of audits. And then also, if you do receive a notice of inspection from ICE, for example, there's some unique California requirements that you have to comply with. So we'll cover that. And then we're going to go over some of the executive orders as they relate to diversity, equity, and inclusion programs. So starting with Form I-9, as a reminder, since 1986, federal law has required employers to verify both the identity and the employment eligibility of all newly hired employees. And we use the Form I-9 to do that. So while you're not expected to be an immigration or document expert, it is your responsibility to review the documents that the employee chooses to provide. So it's always their choice whether they're bringing in a combination of list B and C, for example, like a driver's license and social security, or a standalone list A document like a passport or permanent resident card. But you have to evaluate, does that document appear to relate to the employee? It's their name or their picture, so it seems to be it's their identity. And is it a legitimate document to show that they are authorized to work in the United States? You do not need to file this with the USCIS or any government agency, but you do need to maintain those records in case you do get an audit, and you need to be able to produce them within 72 hours if you get that notice of inspection. And of course, there can be very steep penalties for failing to comply with this process or for hiring someone that you don't confirm is authorized to work in the United States. Now, if you do need some additional guidance in this area and on the Form I-9, the USCIS has a great handbook known as the M247, and it answers a lot of frequently asked questions about completing the I-9. But I want to jump in with just a little pop quiz, and you can go ahead and go to the chat box and let me know here. So we have a new employee. They started work on Monday. We want to know, when is that deadline to complete their Form I-9? Is it A, Monday, on or before their first day of hire, B, Thursday within 3 business days of hire, or C, within 7 calendar days of hire? Let me know what you think in the chat. All right, we already have a very savvy group. Thank you for responding so quickly. The correct answer is B. So while the employee has to complete Section 1, the employee information section, by that first day of hire, you have until the 3rd business day to complete Section 2, which is that employer section where you're reviewing their documents. The only exception to that is if you're hiring someone for less than 3 business days, maybe you're just hiring them for the day for a temporary assignment, then you need to complete the whole I-9 form by that first day of hire. So we usually recommend if you have a new hire, inform them that they should bring their I-9 documents. You're going to want to provide them the list of acceptable documents and instructions. Inform them to bring that on their first day of hire, just in case they bring the wrong document or the incorrect combination of documents. You still have some time before you hit that third business day. All right, so it is good to know that there is a new I-9 form version out there with an edition date of 1/20/2025. And there weren't a ton of major updates most recently. Really, some of the changes were made to align with the ideology and policies of the current administration. So some small changes that you might see is instead of it being labeled a non-citizen authorized to work, that's now labeled an alien authorized to work. They replaced the word gender with the word sex. So pretty small changes. The last time the I-9 form went through really a major overhaul was back in August of 2023. And that was when it was reduced to a single-sided sheet. They really tried to strive to make it a little more user-friendly. So sections 1 and 2 are on one page. It's designed to be a fillable form on tablets and mobile devices now. So yes, you can fill out the I-9 form electronically and maintain it electronically. There's specific steps you have to do to maintain it properly, but you can do it that way. Some other changes. So it used to be that preparer translator certification was in section 1 of the form. Now that's a separate supplement A. You only need to fill it out and attach it to the I-9 form when you have helped the employee complete that section 1. Maybe you helped them fill it out, or if you translated section 1 for them. That's when you need to complete that supplement A. Another change, so what was known as section 3, re-verification and rehire, is now that standalone supplement B. Again, you only need to use this if you have a rehire or re-verification. So for rehire, when you're rehiring someone within 3 years from them originally completing the I-9, you can actually just complete supplement B. But if it's been more than that, then you have to complete a whole new I-9 form. And then re-verification is required in certain circumstances for certain work authorization documents that are set to expire for aliens. You do not have to re-verify US citizens, non-citizen nationals, or identity documents like somebody's driver's license expiring. So really that's only going to come up in a pretty narrow set of circumstances. All right, so a question we've been getting is, do you need to correct or replace I-9s of current employees because there's a new form version? And the answer to that, luckily, is no. So as long as the version that you used was not expired when you completed that I-9 form for them, there's nothing that you need to do or any additional steps you need to take aside from those re-verification situations that I just mentioned. If you have a work authorization document that's set to expire, then you need to re-verify by that date. But otherwise, you want to just maintain those I-9 records as you completed them. We want to make sure we have them on file for all current employees. For former employees, we can get rid of them once it's been 3 years from the date of hire or 1 year from the termination date, whichever comes later. All right, so now I want to talk a little bit about auditing your I-9 forms. We would recommend that you're auditing I-9 forms on at least an annual basis. And the reason that we recommend that is that it gives you an opportunity to correct errors before you ever receive a notice of inspection from a government agency. So you can actually potentially avoid penalties by finding and correcting those errors before you get that notice of inspection. Another reason is that it has a tendency to show good faith. So you want to remember when it comes to penalties, there's usually a minimum and a maximum penalty depending on the type of violation. And if it looks like you're an employer that's trying to comply, that's auditing your I-9 forms from year to year, that can just tend to show that good faith that might weigh in your favor. So what we generally recommend is first, discard those I-9s that you're no longer required to retain for your former employees. So you can check their file to see when they've met that record retention requirement. And then we would recommend discarding those when you're no longer required to have them, just because you don't want it to hold on to them and then there'd be a potential error that you never needed to even hold on to, right? Then when it comes to the I-9s that you need to currently have on file, as you're going through and auditing them, if you do find an error, generally what the guidance states is you're going to want to draw a clean line through the incorrect information, enter the correct or missing information, and then initial and date the correction. What we never want to do is we never want to backdate or use whiteout or attempt to conceal the error. We should always see what the error was and the correction that was made to that. For Section 1 issues, it's the employee or their preparer or translator that would have to correct that. And for Section 2, it's the employer. Now, if it's a major issue, you realize that they didn't have the proper work authorization documents. In that case, what's advised is that you complete a new I-9 form, but you're going to still want to hold on to that original and attach it to the original. So we never get rid of the original I-9 form. And then lastly, what's recommended is you prepare a written explanation, kind of what the circumstances are, your good faith efforts to correct it, and then sign, date, and attach that to your I-9 records. And if this is something that you need some additional assistance with, this is one of those services that CEA can help you out with. All right, so now let's say you do get a notice of inspection from a government agency like ICE that they want to review your I-9 records. Typically, we need to produce those records within 72 hours. So what we highly recommend is that you keep I-9 records separate from personnel files, keep them in their own confidential binder, maybe alphabetically for all your current employees and then all your former employees, so that you can produce them within that 72-hour requirement. Now, in California, we have an additional obligation. When we receive a notice of inspection, we have to give our employees notice of that within 72 hours. We have to post that conspicuously in our workplace, basically giving them a heads up that we've received this notice of inspection from the government agency. And then if there's any employee that's identified as potentially lacking proper work authorization or having deficient documentation, we have to notify them directly of that finding. Again, we have 72 hours in that case. So we need to distribute this notification to them directly. If they're not in our workplace, we can't locate them for some reason, then the guidance says to send that by mail and email. And for this general notice of inspection, the California Labor Commissioner does have a template notice available for you to use if you need it. All right, so that's a notice of inspection related to I-9 records most of the time. Now, a separate issue is what's known as an ICE raid. That is when ICE is actually or a government agency is actually showing up to the workplace. Typically, it's to gather evidence or potentially arrest someone. Typically, you don't have notice of that. It's usually unannounced. And so we have been getting a lot more questions on, well, how do we prepare for these types of ICE raids? So some things that you can keep in mind is that they cannot enter any non-public areas unless they have a valid judicial warrant to do so. So some of the steps you can take when they show up at your workplace, you can ask them for their name, badge number, and the warrant if they have one, and then you are going to want to document that for your records. Now, any public areas like parking lots, waiting rooms, areas where your customers can be present, they would have a right to access without a warrant. So it could be helpful if you're concerned about this to mark areas as employee only or authorized access only very clearly. So you indicate what are those public versus non-public areas. Some other things to know, workers do have a right to remain silent under the Fifth Amendment. And some other tips that we've heard is to let your workers know that if they go off running when ICE shows up, that can actually give them a basis to arrest that person. So be aware of that. The CEA has written a number of articles on this. If you want additional resources and guidance that you can locate on our blog, I'm sure Anna will put them in the chat as well, if you'd like some more information in this area. All right, so we're going to want to ensure a compliant process for completing Form I-9s at the time of hire. We need to do this for every new hire that we employ. We want to make sure that we have a good process for auditing our I-9 forms and records. We would recommend on an annual basis. And then be prepared if you do get a notice of inspection to follow those additional California requirements. All right, so now I'm going to shift gears a little bit and go over some of the executive orders that relate to diversity, equity, and inclusion programs. But I wanted to start with just a little bit of context with where does DE&I stand today? What's kind of been the history over the years? So diversity programs in corporate America arguably started to first appear in the 1980s and 90s. And it was really known as just diversity back at that time. And there's been kind of increased attention on diversity in the workplace during certain periods of time and then less attention in others. So it's kind of gone, up and down throughout the years. Most recently, you might remember there was a lot of attention on it back in 2020 with the George Floyd and Breonna Taylor incidents, where you might have seen a lot of corporations very openly showing their support for their diversity and equity and inclusion programs, maybe even hiring DE&I officer or specific roles like that. And then you might have noticed recently in 2025, kind of this cultural shift with large companies pulling back from DE&I programs and initiatives. So some examples are Target, Walmart, Amazon. So you might be wondering, well, what's kind of going on here? And arguably, the executive orders really had a direct impact on that cultural shift in corporate America. So I want to talk to you about just a couple of these. The first one being Executive Order 14173. This is known as Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So this executive order basically just takes the position that certain DE&I programs create discriminatory preferences for minority groups, such as in hiring or who to promote, that would violate federal civil rights laws. So that's one big component of it. Another part is that it revoked federal contractor and subcontractor affirmative action requirements that have been in place for years. So it used to be that a lot of federal contractors had to maintain these affirmative action programs, audit them, and make sure that they were providing opportunities to underrepresented members of the community. That's kind of been flipped now. Now these federal contractors have to certify that they are not maintaining programs that would violate federal civil rights laws or giving preferences to certain groups. Another piece of it is the executive order requires the Attorney General to provide recommendations for combating what's known as illegal DEI and basically identifying, I think it was a list of 10 high-profile large publicly traded companies or nonprofits to go after in terms of enforcement efforts if they had this illegal DE&I program. So now you can kind of see the picture why we see this big shift away or kind of pullback from that. There is new EEOC guidance on what DE&I related discrimination means. So we have this bit.ly link here you can put in your browser if you'd like to access that for more information. But I want to answer the big question, does EO 14173 make a DE&I program illegal? So could you maintain a DE&I program at your workplace? So no, it does not change our discrimination laws, and it does not make a DE&I program itself illegal, but you do need to be cautious that employment decisions are not based on a protected characteristic. So you want to remember whether someone's in a minority or a majority group, employment decisions should not be made based on that person's race, gender, religion, etc., any protected class. That has actually always been illegal under both federal and state law. As a practical matter, though, employers with DE&I programs may come under increased scrutiny and enforcement, and particularly these large corporations. So that's how we might kind of see it play out as a practical matter. All right, so some reminders here. It's not unlawful to maintain a diverse and inclusive workforce, but you do want to ensure that your employment decisions, whether that's related to who you hire, who you promote, or who you give special assignments to, are not giving preferential treatment based on a factor like race, sex, or any other protected class. So you want to train both your internal and external recruiters and your management team We do not want to have quotas based on race or sex. So we don't want to say we need to hire, 50% or 60% women. So we don't want anything like that. We also don't want preference points for applicants of certain protected classes or minority groups, where basically you're giving them a leg up in the process by giving them additional points towards their overall applicant score based on something like a protected class. Another important thing to remember, voluntary employee membership groups should be open to all. So we need to be careful not to have women-only groups or groups based on race. Voluntary groups should be open to all. Some other tips here is to maintain updated job descriptions for your positions and draft your hiring criteria in advance. If you have objective criteria that you can point to and justify your decisions, you can say, this is why we hired this person. They met these qualifications, to show that it didn't have to do with a protected class issue. So that can be very helpful. All right, the second executive order that I want to cover with you is EO 14168. Bear with me because this is a mouthful. Defending women from gender ideology extremism and restoring biological truth to the federal government. So basically, this executive order states that the federal government will recognize only two sexes, male and female. It defines sex as an immutable biological classification and rejects the concept of gender identity. And it rejects interpretation of Supreme Court rulings, including regarding sexual orientation and gender identity, as requiring gender identity-based access to single-sex spaces like restrooms, locker rooms, changing rooms, etc. So just to give a little more context on that one, Supreme Court cases like the Bostock case says that Title VII's definition of sex includes protections for those based on sexual orientation and gender identity, but those cases have not yet addressed things like gender identity-based access to restrooms, locker rooms. So basically, the executive order and also the EEOC in line with that is saying we're not going to interpret that case law as going that far, as requiring that. So the $1 million question here is, what does this mean for California employers? Is this in conflict with California law? So we'll have to see if the federal law and California law go head to head in any fashion, but we do want to remember that state law, California law, can be more restrictive and more protective than the federal requirements. So under California's Fair Employment and Housing Act, gender identity and expression are protected classes. They're required to be covered in mandatory harassment prevention training. And our FEHA regulations require that employees have a right to use a restroom or locker room that corresponds to their gender identity, and also be addressed by the name and pronouns of their gender identity or expression. So our Civil Rights Department is very clear in their guidance that if you are intentionally and repeatedly using different pronouns than what someone selected, or is not giving them that gender identity-based access, that could actually lead to a harassment or discrimination claim under FEHA. So be careful of that. The rules are different there in California. All right, so what are our to-dos in this area? Really good idea to review your hiring and internal policies, including and using recruiters to ensure that no preferential treatment is being given for certain groups. Draft objective job-related criteria in advance and then train your hiring managers on that. Maintain current job descriptions for all positions. That's really just a good idea for so many reasons. It can also be very helpful if you get a reasonable accommodation request and you need to look at the essential job functions. And then finally, continue monitoring federal developments and pending litigation. There's been a lot of litigation as far as the executive orders are concerned. As of right now, they are, for the most part, fully enforceable, but you want to stay tuned to see what happens on that. And one way you can do that is by following our blog at employers.org. That is where we publish articles on HR updates, so that can be helpful to stay in the know. All right, so now we are going to shift gears and move away from the federal updates and focus on California, starting with wage and hour. So as I mentioned, we have a lot of local minimum wage increases that happened recently on July 1st, some industry-specific wage increases. I'm also going to go over some new case law with you, as well as recommendations regarding wage and hour audits based on some new legislation that happened last year. All right, so let's just start with our state minimum wage, where we stand today. So for our non-exempt hourly employees, we are sitting at $16.50 an hour. And we want to remember that every time the minimum wage goes up, that also impacts the exempt salary minimum threshold. So that's always 2 times the state's minimum wage times 80 hours a year gives you that annual rate. So for the white collar professions, they have to meet a duties test and they have to be paid this salary minimum of $68,640. We cannot prorate that based on hours worked. So if someone is exempt and they're working just very part-time hours for you, they would still need to meet that minimum. So some employers realize, well, this is not in our financial best interest, so it actually probably makes more sense to reclassify this person to non-exempt. So we can classify anyone as non-exempt. That's the default in California, but to be exempt, we have to overcome a couple of those hurdles, the duties and the salary test. We do, again, have a great resource for you if you do need to transition someone from being exempt to non-exempt, especially if they were never an hourly employee before and they need some freshening up on timekeeping, meal and rest breaks, those types of issues. So again, you can put this bit.ly link in your browser and access that. All right, now in California, of course, it's not quite that simple. We also have now over 40 different local minimum wage ordinances that might apply. We're also starting to see some additional local ordinances based on things like predictive scheduling. So especially if you have workers in larger metropolitan areas around the Bay Area or Los Angeles, really always important to look into those local laws. Now, when it comes to the local minimum wage, that is based on where your employees are physically working, where they're performing the work. So you want to consider your remote or hybrid workers if they're working in a different city or locality than where your headquarters might be located. And then also if you're sending workers to different job sites or client sites, you're going to want to check those local minimum wages. A lot of the local minimum wages go up on January 1 each year, but there's a good batch of them that go up on July 1. So just to give you some examples for Southern California, the city of Los Angeles got bumped up to $17.87, Los Angeles County, $17.81, Santa Monica is also $17.81, Pasadena, $18.04. So we have a great fact sheet for you. You can put that in your browser, and that lists all of the current local minimum wages, including those that went up on January 1. So they're all throughout both Northern and Southern California. So I would advise to take a look at that resource. All right, and we now also have specific healthcare minimum wages in California, and that went into effect last year, back in October of 2024. The bill was known as SB 525, and it really had this goal of healthcare workers in California eventually earning $25 an hour. And I think a lot of that was probably from the pandemic and kind of the attention on our healthcare workers during that time. So what happened, it got delayed a number of times. It eventually went into effect in October of last year, and it applies to almost all type of healthcare facilities. And the minimum wage requirements range depending on the facility type. So it was initially anywhere from $18 to $23 an hour. Some of those facilities had increases on July 1. So some examples are dialysis clinics and very large hospitals went up to $24 an hour. If you are in the healthcare space, I would recommend that you take a look at the healthcare minimum wage FAQs by the DIR. They list the different facility types, when your next increase is expected, so that's very helpful. There's also now a new supplemental minimum wage poster for healthcare that has the updated amounts on there from the DIR. So if you are a healthcare employer that's covered, make sure you have that updated poster. It's also important to remember when it comes to the healthcare minimum wage, we have a special rule with how that impacts exempt employee salaries. So to be classified as an exempt healthcare worker, if you're covered under the law, you must be paid 1.5 times the healthcare minimum wage that applies, or 2 times California's minimum wage, whichever is greater. So that means healthcare employers, every time California's minimum wage or the healthcare minimum wage goes up, they have to do a little math calculation to see which one is greater and what that exempt employee salary threshold is. All right. So I mentioned that we have a new case on meal breaks. It's actually on meal break waivers. So I want to go over a little refresher on our meal break rules in California, and then we'll jump into the question that was asked by the case. But remember, in California, for our non-exempt hourly workers, anytime they work over 5 hours, we have to provide them a meal break. It needs to be at least 30 minutes, uninterrupted, complete personal time, and they are clocking in and out. It's an unpaid meal break. Now, we do have the ability to waive that meal break, or they have the ability to waive it voluntarily if their workday is going to be 6 hours or less. So again, if they go over 5 hours, they're entitled to that meal break. But if it's going to be 6 hours or less that will finish out the day, then they can voluntarily agree to waive it by mutual consent of the employer and the employee. For the second meal break, if someone works over 10 hours, then they're entitled to a second meal break that's uninterrupted, 30 minutes long. Again, they could waive it if their total workday was no more than 12 hours and the employee in that case had to take the first meal break. And if both the employer and employee mutually agree to that, they can waive the meal break. Now, a lot of employees do often want to agree to that because it allows them to go home a little bit earlier. As opposed to if they have that 30-minute meal break in there, it's going to push their day back by 30 minutes. So a lot of employees do prefer to waive it, but again, it's their choice. Now, this question came up that was answered by the California courts recently, and I want to know what you guys think the answer was here. So we present all new hires that may work shifts of 6 hours or less with a voluntary meal break waiver to sign at the time of onboarding for future work shifts. So they got one meal break waiver at the time of onboarding that'll apply to 6 hour or less shifts. They don't get individual waivers every time someone waives their meal break. Is this practice okay? Let me know what you think in the chat, and then we'll find out what the California court said on this. All right, so we have a couple guesses here. We have a couple no guesses, a couple yeses coming in. So I would probably be inclined to guess no, because California court cases tend to be more employee friendly, but it was actually determined that this practice is okay. And thank goodness, because this is a practice that a lot of employers have implemented for years. So it really just kind of confirms that it is okay. So this case was known as the Bradbury versus Vicar case. And the court there found that employees can make those advanced written waivers of meal periods for workdays of 6 hours or less. In this case, they did not address oral or verbal waivers. So they said here, they highlighted the waivers were in writing. They were completely knowing and voluntary. So the employees knew what they were giving up. The waivers were really clear that they were revocable at any time and there was no retaliation for revocation. So basically the employer did everything right in setting up this waiver, and it was okay to just get one waiver that would apply at the time of onboarding, but could be revoked by employees at any time in the future if they decided to. So some best practice reminders in this area. Make sure if you do have a waiver that it's really clear about the right to revoke, clearly written about how it works, and explain to employees before they sign. If you are a CA member, we do have a sample waiver form that you can use for that. And then really important that you also train your supervisors to never pressure employees. So we don't want them saying things like, well, you're going to be the only person, that's not waiving the meal break, and put pressure on them. We wouldn't want to do that. That's just a good rule of thumb to train your supervisors on that in general when it comes to meal and rest break rights. We don't want to pressure them to work through the meal break either. So some good best practice takeaways there. All right, and the last wage and hour issue that I really want to go over is this PAGA reform that happened last year. So PAGA is known as the Private Attorneys General Act. And this is the law that basically allows employees to step into the shoes of our labor commissioner and go after labor code or wage and hour violations, not only on behalf of themselves, but on behalf of other employees. And the penalties can stack really quickly. So it's a little bit different from a class action lawsuit, but there's a lot of overlap and similarities with a class action lawsuit. Now, there's been a lot of criticism from business groups and employer groups over the years regarding PAGA because there's some employers that they're trying to do everything right and they get hit with all of these penalties, and sometimes they'll get hit back to back with PAGA lawsuits. And there's an argument that it's really just plaintiffs' attorneys that are really benefiting the most from this law. And so there was this push to basically put it on the ballot to almost entirely gut PAGA as we know it, almost entirely get rid of it. But what happened kind of at the 11th hour is that business groups and employer groups kind of came together and made this deal that ultimately became legislation. And so we still do have PAGA. We didn't get rid of it, but it is a little more employer friendly now. So there's some opportunities to cure following a PAGA notice. A lot of it's really more relevant for litigators who are litigating these types of cases. But there is something that I really want to call your attention to that happened as a result of the PAGA reform. And that is that there are now new opportunities for employers to reduce their PAGA penalties. In some cases, it could be up to 85%. So that could be tens of thousands, if not more, dollars, if they can show that they were taking reasonable steps to comply with wage and hour laws. And the legislature is actually very specific regarding the reasonable steps that they want to see employers taking to be able to reduce their PAGA penalties. So they said it includes this: periodic payroll audits and taking action in response to results. So we should be looking at things like, are we following appropriate meal and rest break practices? When employees are missing their meal and rest breaks, are we paying premium pay? Are we calculating the regular rate of pay and overtime properly? Do we have all the required information on the wage statement? Those would be the types of different issues that you should be auditing and correcting. The next thing would be distributing lawful written wage and hour policies. So you're going to want to keep that employee handbook up to date. And it's a really good idea to have your employees acknowledge your policies on things like timekeeping, meal and rest break rights, and those types of issues. Next, they listed training your supervisors on basically wage and hour rules and requirements. So they didn't go so far as to make it required training like we have with harassment prevention training, for example, but now there's a really big incentive to actually provide some level of formal wage and hour training for your supervisors. And then finally, they said taking corrective action for supervisors who are not following your policies. So for example, if you do have one of those supervisors that is pressuring people not to take their meal or rest breaks or interrupting them with, I have just a quick work-related question. We want to make sure that we're coaching and disciplining that supervisor as appropriate so they understand the wage and hour rules and protections. CEA does offer a wage and hour audit do-it-yourself package if you need some additional assistance in this area. So it includes an audit checklist of areas to look over and review. It also comes with a wage and hour training, a 30-minute training for supervisors on wage and hour fundamentals. So if you do need that, it is accessible at employers.org on our store. All right, so wrapping up our wage and hour to-dos, we want to ensure those minimum wage rates are adjusted as needed, review those local ordinances, and make sure you have the appropriate salary for your exempt employees. Take a look at your meal period waiver practices. If you do have meal period waivers on file, are they really clear? Is it clear about the right to revoke? And then this one I would make sure to follow up on. Make sure you have a process for implementing those reasonable steps in light of the PAGA reform. We are hearing that, in the past, it used to be a lot of larger employers that would get targeted for those PAGA penalties, but now we're hearing more recently it's even mid-size and smaller employers that are starting to get hit with PAGA lawsuits in the past few years. So really good idea for everyone to stay on top of that. All right, so now we're going to go over some employee rights and protections, those new AI regulations, a case law update on reasonable accommodations, and some new poster and notice updates. So first, our Civil Rights Department back in March approved regulations addressing when employers basically use AI tools to make personnel decisions. So you might have noticed out there now in hiring, AI is used to screen applicants, for example. So now we have some standards around that. The effective date of these regulations is going to be October 1st, 2025. So that's coming up in a couple months. And it regulates what's known as automated decision-making systems, such as artificial intelligence or AI, machine learning, statistics, and other data processing. Now, I don't think these regulations are really anything super surprising or what we kind of don't already know, but just some key highlights. They basically, I think, kind of just confirm how our Fair Employment and Housing Act works when it comes to harassment discrimination. So they say FEHA does apply to the use of artificial intelligence. So basically, you are using AI at your own risk. AI tools may result in what's known as adverse impact discrimination. So that is when an AI tool maybe is inadvertently selecting out a certain protected group. There's already a case at the federal level known as Mobley versus Workday, where that's the argument being made, is that these AI screening tools were screening out candidates over 40, which is a protected classification. So even though the employer might not be doing that or want that intentionally, they could still face an adverse impact discrimination claim under FEHA. Some other clarification: AI alone is insufficient for criminal history individualized assessment. So you might recall that if you are denying employment based on criminal history, before you do that, you have to make an individualized assessment looking at certain factors on a case-by-case basis to make that decision. And so they're just saying you cannot use AI alone to do that. You have to have a human involved in that process. They also came up with some new record retention requirements. So very important to know that if you're using AI to make personnel decisions, you have to maintain those records. And that is for a period of 4 years, either from the date you create the records or the date you take the personnel action, meaning who you choose to hire, for example, whichever comes later. All right, so now I want to talk to you about this Manos versus Getty case. It can be kind of helpful when it comes to dealing with issues like unpaid leave as a reasonable accommodation. So the facts of this case, there was Manos. He worked at the Getty and he fell off of a ladder one day and broke his arm. And he first took some family and medical leave for that, exhausted his CFR FMLA, for example. And then he requested further unpaid leave as a reasonable accommodation under FEHA or the ADA. Now, what ended up happening in this case is the employer granted multiple leave requests. I think there was 4 of them ultimately, for about a year. And in that final request, Manos requested indefinite leave, meaning there was no expected end date. And the Getty reached out and they actually sent a questionnaire regarding, are there any other accommodations we can provide you to get back on the job, maybe in a modified duty capacity? And Manos responded, nope, all I need is this indefinite leave of absence. And so Getty then decided to terminate his employment. And you might be surprised to hear that the court actually ruled in the employer's favor. So they highlighted the employer's good faith efforts in engaging in that interactive process and the fact that they repeatedly granted these unpaid leave requests for about a year and that they reached out to the employee to explore other accommodations. Now, the reason that we are going over this case is it does highlight that there is no obligation to grant indefinite leave with a no expected end date. But it's also a good example of kind of everything the employer did right in this circumstance. You know, after the family medical leave, they didn't just say, that's it, you know, we're done here. They continued to reasonably accommodate and try to engage in the interactive process. But with that said, there is no bright line rule for the duration of unpaid leave as an accommodation. So there's no period of time when it would necessarily be safe to end employment. It's always important that you're engaging in the interactive process, exploring accommodations. And in these tricky type of situations, we would always recommend consulting legal counsel before ending employment, just because they're so fact specific and they can all be a little bit different. All right, and then on labor law, posters and notices, just a couple updates here. So that EEOC Know Your Rights poster has been marked as undergoing revision due to President Trump's executive order. So you should be on the lookout that there might be an update with that mandatory posting. As I mentioned, we want to make sure we have our supplemental minimum wage posters if you're in healthcare, fast food, or you have a local ordinance that applies to you. And then here's a pretty important one, the California Civil Rights Department Crime Victims Notice. So back earlier this year, you might have recalled that the crime victims leave was expanded, especially if you have 25 or more employees. There's a lot more requirements now. But part of that law was that the Civil Rights Department had to update the notice for all employees, for employers of all sizes. And they had until July 1 to do that. And what the law says is once the Civil Rights Department publishes that notice, which they now have, you have to distribute it to new hires, annually to all employees, and then upon request or anytime someone informs you that they or their family member is a crime victim. So here again, I would mark your to-dos. I would distribute this now, if you haven't already, to all employees, and then mark your calendars to distribute it again next year, and then also include it as part of your onboarding paperwork now as well. All right, so some reminders here. You want to ensure human review of AI processes and make sure you're meeting those record retention requirements. We would actually also recommend drafting a specific AI policy for your staff. You know, whether you love the use of AI or you don't want anything to do with it, it's still a good idea to just outline clearly for your staff what the permitted uses are or not, confidentiality concerns, plagiarism, those types of issues. Train your management on leaves of absence and reasonable accommodation rights, and then watch out for those updated posters and make sure you're distributing that crime victims notice from the Civil Rights Department. All right, and finally, I'm going to now go over some summer reminders for California employers when it comes to heat illness, workplace violence, and then also Cal Savers. So it is heating up in California, and you want to remember that last year, back in July, Cal OSHA implemented their indoor heat illness standard. So outdoor places of employment have already been required to have heat illness prevention plans for a number of years, but now we have this relatively new indoor standard. Now, you also want to know that this indoor standard applies to indoor work areas when temperatures reach or exceed 82 degrees while employees are present. And that's really the only qualification. So while it's aimed at places like manufacturing and restaurant kitchens, it could be an office environment if you don't have full air conditioning. So what that means is you would need to have a written heat illness prevention plan and follow certain requirements when the workplace exceeds 82 degrees. So some of those essential requirements include providing fresh drinking water at no charge to your employees, making sure that they can take cool down breaks in cool down areas that are shaded, less than 82 degrees, that you're engaged in emergency response, and you know what the steps are if someone's exhibiting signs of heat illness. And then for newly assigned employees or new employees, that you're going through acclimation procedures to make sure that they're acclimating to the heat. So we need to have our plan. Cal OSHA has a template for both indoor and outdoor. It will run through a lot of these requirements and allow you to customize that plan for your business. So in addition to that, you also want to make sure that you're training your employees and supervisors on heat illness. And then there are some additional high heat requirements that can kick into effect in certain cases, such as when your workplace exceeds 87 degrees, then we might have to consider some other engineering or administrative controls to bring down the likelihood of a heat illness issue. All right, now I want to go over some of the requirements that are required on an annual basis when it comes to that workplace violence prevention plan. So we might recall that almost all California employers as of July 1 of last year, 2024, had to develop a workplace violence prevention plan. So hopefully you got around to doing that. But remember, we want to revisit that year to year. So what is required under the law is that we are reviewing our plan annually and updating it as needed. So you want to take a look at, did we have a workplace violence incident? Do we have any new hazards? Maybe we have a door that's not locking properly, or the lights have gone out in our parking lot. We're concerned about incidents. So what are things we can do to update the plan? Another component, we actually have to solicit feedback from our employees annually on our plan in certain areas, on certain topics. And we have to provide them annual employee training. So that training needs to be specific to your plan. It needs to be delivered by someone who's knowledgeable in your specific plan at your workplace and can answer questions for employees on things like reporting procedures and unique hazards. And there's also some required definitions from the law that need to be included in that training. Some other things we should be doing is periodic hazard inspections, and we would also recommend periodic safety meetings where you're getting feedback from your team on any concerns. Again, we do have a comprehensive do-it-yourself package if you need help putting this together or meeting these requirements. In CEA store at employers.org, we also do have a customizable PowerPoint template with the definitions and included topics that you can customize and deliver to your staff. All right, and finally, I know I've gone over a lot of information with you. This is the last topic, CalSavers retirement. So again, remember, for California employers who do not offer a qualified retirement plan, such as a 401k or other retirement plan, you need to enroll your employees in CalSavers. So that is the retirement savings program run by California for those employees that don't have the opportunity to enroll in one through work. And they phased in the requirements to register with CalSavers based on employer size. So now if you have just one or more employees, the deadline for you to register or to claim that you're exempt is December 31, 2025. So take a look at CalSavers website. If you haven't already done that, make sure you comply by that deadline. There's no fees for the employer, but you do have to maintain the employee roster. So there's administrative requirements, and your employees also can choose to opt out, but they're automatically enrolled. So that's how that works. All right, so with our summer to-do list, make sure you're complying with annual workplace violence requirements, including that staff training, develop those heat illness prevention plans, and small employers prepare for that CalSavers deadline. EA does have safety partners, including Safety Center and Safety Compliance Company, that can also help you out with your safety-related needs and issues. All right, so just to recap our training today, make sure you're staying up to date on all of the required trainings in California. So mandatory harassment prevention training is due every 2 years, that annual workplace violence training, and then now we would, of course, recommend the wage and hour training for your supervisors. Keep your employee handbook up to date, comply with all of the new wage requirements, and pay attention to those local ordinances. And then make sure you have an updated labor law poster in your workplace, distribute that crime victims notice, and then stay tuned with all of the HR developments. You can follow us on CEA's blog at employers.org. All right, so again, I want to give a big thanks to the San Bernardino County Workforce Development Board for sponsoring this event today, and remind you, you guys do have that HR hotline. If you have any questions after this training, you can call in to the hotline number provided by San Bernardino. And if you find that you do need some additional HR support, you can also join us as a CEA member. Depending on what level of HR support you need, you can join us for as little as $125 a month on a month-to-month basis, and that would give you access to all of those forms that I mentioned. So with that, I will turn it back over to you, Anna. I've been talking for quite a bit, so I'll let you take over here.
You are a queen. Let's see, copy that over. Something is weird with my commands today. There we go. So I just dropped the link into the chat for a couple of things. If you haven't been following along, there's a lot of links to additional resources to correspond with what Juliana was covering. So make sure you open up any that you need some additional help with. But the last two I want to specifically draw your attention to. So one is the next training coming up in August. Again, complimentary thanks to our partners over at San Bernardino County. That's coming up in August, Coaching for Success. So go ahead and click that and then register for that as soon as we wrap here. Next is the one that you see on your screen. So I dropped a link into the chat. You can also scan that QR code. You can choose your own adventure today, but that will take you to a very brief survey, 5 questions. That's how you share how we did today, what you'd like to see topic-wise in the future. Really encourage you to take a minute there. And let's see, if you are joining us for continuing education credits, we have those on the screen, and I'm going to drop those also into the chat. HRCI code 710041, SHRM code 25-XEQQ3. Please always call into that HR hotline or reach out to us at ceainfo@employers.org if you ever need any guidance on how to make sure you get credit for attending live today. With that, I want to thank Angelica, Carmela, everyone behind the scenes over at San Bernardino County. Is there anything else that you'd like to leave us with today before we wrap?
No, I just want to say thank you to everyone who attended, and I look forward to seeing you in our next workshop. The link has been dropped in the chat, so if you have any questions, feel free to reach out. Thank you, ladies. Thank you, everyone.
Excellent. Thank you again for everything that you do for employers and HR professionals. Thank you again, Juliana and Mary, for sharing your time and expertise today. I did see a question about the slides, so I did just drop them in again if you didn't capture those at the beginning. And thank you all for all your kind words in the chat. Take the survey if you're able, and we'll look forward to seeing you all again in August. Enjoy your day. Thank you.